I was sitting on the back seat of a car which was parked to the side of the road.
Hmm.
I mistakenly opened the back door. मैं अपनी दुकान में बैठा था, तभी मेरी दुकान के सामने रोड के दूसरी ओर एक काले रंग की XUV महिंद्रा कार. My lords, this is a miscellaneous petition by way of which we are challenging the order passed by the learned judicial magistrate first class, by virtue of which he took cognizance for an offence punishable under the erstwhile 304A of the Indian Penal Code. So, in a sense, we are challenging the order of cognizance, charge sheet, and FIR as well. Now, my lords, the grounds are that if my lords will see the FIR, the nature of the offence is such that I was sitting on the back seat.
Is taken on private complaint or police complaint?
On a police report, on a charge sheet. If my lords will see the order, beg your pardon, my lords?
It's not a revisable order.
No, my lords. Cognizance order will be challenged under 227 or 482. We've challenged it in 227. That is as per the judgment of the Supreme Court. Because it's an interlocutory order, it will not be revised.
Charge is not framed.
Charges are not framed yet. Very recently, cognizance was taken.
Cognizance taken by?
Judicial Magistrate First Class. That is Annexure P2.
So it is triable by magistrate or sessions?
It is triable by magistrate.
So now it is posted for arguments on charge. You argue on charge.
No, we say, my lords, that cognizance itself would not be correct in the facts. In fact, it would amount to where my lords are exercising somewhat inherent powers under the supervisory jurisdiction only. We say that the ingredients of the offence itself are not made out. And for that purpose, a charge sheet itself could not have been laid against me, may have been laid against the other accused person, because of course an offence has happened. If my lords will permit me, I'll just try and make out a case. Facts very simply are that I was sitting on the back seat of a car which was parked to the side of the road. I mistakenly opened the back door towards the road. At that point, a motorcyclist was coming. He dashed into that car, fell to the ground, and after that, there was a truck which was coming, being driven rashly and negligently, and that truck crushed this person and went away. Now, my lords, the law on this issue, which I'll very shortly be taking my lords to, which is the second judgment uploaded on the ERP, on the reference column of the ERP, that laid down the legal position of an offence for death by negligence. Just before I take my lords into the judgment, it describes two propositions of law. The first proposition being a proposition of causa sine qua non, and the second proposition being causans. Causa sine qua non being, even if my act is the essential ingredient of the cause of action, that is not sufficient for under 304A. The law is my act without the intervention of any third act has to be the cause of action of the offence. If my lords may kindly have the second 1972 volume 3 SCC 525, which I have uploaded for my lords on the reference. If my lords, I could just have the first page only. What has been held, those two paragraphs, they crystallize
how much application of mind has to be there at the time of cognizance?
My lords, we say that there cannot be an FIR registered against me, and because of which the court, the police may not have laid a charge sheet against me, and because of which cognizance would be illegal. It is essentially a petition requesting my lords to exercise their inherent powers only, but in the form of 227, because cognizance has been taken. 2025 Supreme Court changed the law for us. Now they say that if cognizance has been taken, one must come under 227 or 482. If cognizance is not taken, then 226/482. That is the thing. But they are equivalent jurisdictions, so to say. It is only the forum which will change. Now, if my lords may just see 1972 volume 3 525, the first page, what has been held. In a prosecution for an offence under section 304A of the IPC, the court has to examine whether the alleged act of the accused is the direct result of a rash and negligent act, and that act was the proximate and efficient cause of death without intervention of others' negligence. The mere fact that an accused contravenes certain rules or regulations in doing of an act does not establish an offence under section 304A IPC. The act causing deaths must be the causa causans. It is not enough that it may have been the causa sine qua non. The court has to determine whether the act of the accused is the causa causans, or has there been a cause intervening which has broken the chain of accusation so as to make the act of the accused, though a negligent one, not the immediate cause or whether it amounts to an act of gross negligence or recklessly negligent conduct. The fact that of course was the fact is 12 lives was lost would not be reasonable. Now the next judgment, my lords, I will not read for my lords, but this next judgment is where this judgment was applied by our High Court in a 482 petition, that is ILR 1992 MP 607, and the proceedings were quashed before the trial court, where this exact judgment of Ambalal was utilized by our High Court in a 482 petition. Now, my lords, coming to the facts of my case, if my lords may have P1, that is the entire charge sheet which I filed for my lords, and I'll specifically invite my lords' attention to the FIR. That is, my lords, on page 30 of P1. Now, could my lords kindly have page 32, which is the contents of the FIR? After having reproduced what is the relevant part of the Dehati Nalsi and so far, the contents of the FIR, my lords, begin from the 8th or 9th line from the bottom. It is Vivran dash maine post office civil lines. It says, मैंने पोस्ट ऑफिस सिविल लाइंस के बाजू में मुन्ना फिश मटन की दुकान चलाता हूं। दिनांक 12/10/25 के दोपहर करीब 1 बजे मैं अपनी दुकान में बैठा था, तभी मेरी दुकान के सामने रोड के दूसरी ओर एक काले रंग की एक्सयूवी महिंद्रा कार क्रमांक UK 07BT 5761, द कार इन विच आई वाज सीटेड, जो कि रोड में खड़ी थी, जिसके पीछे की सीट में बैठे व्यक्ति ने बिना देखे बिना संकेत दिए लापरवाही पूर्वक एक्सयूवी वाहन का पीछे का गेट रोड की तरफ खोल दिया, जिससे उसी समय मोटरसाइकिल से गुजर रहे रमेश जाटव की मोटरसाइकिल से गेट टकरा गया, जिससे रमेश जाटव मैं मोटरसाइकिल के रोड में गिर गए। तभी सामने से आ रही लोडिंग वाहन 407 क्रमांक सच एंड सच के चालक ने तेज गति व लापरवाही पूर्वक वाहन चलाते हुए रमेश जाटव के दाहिने तरफ शरीर में वाहन चढ़ा दिया, जिससे रमेश जाटव गंभीर रूप से घायल हो गए, जिन्हें मेरे द्वारा तुरंत ओमेगा अस्पताल में भर्ती कराया गया, जहां इलाज के दौरान उनकी मृत्यु हो गई। Now, if my lords may also have the 161 statements, it turns out that after this incident happened, I also got down from the car, I also assisted in taking him to the hospital, even I went to the hospital with him. Now, be that as it may, what my submissions over here are, my lords, in light of the law which we just read of 78, I say that my act may have been a negligent one. And because of my act, the injury which has been caused to him, or what was the reasonable, foreseeable future of my act or my negligent act, was that he takes to the ground. But at that unfortunate or misfortunate moment, there was a truck which was individually coming rashly and negligently and speedily driven, which misfortunately crushed him, and unfortunately he succumbed to the death because of that. Even if my lords will see the post-mortem, the cause of death is most certainly the crush injuries. Now, what I submit, my lords, on a reading of this, my act of negligently opening this door, because of which he may have taken to the ground, would be most certainly a causa sine qua non. That is an essential ingredient of the act. But had there been no intervention of the third element of the truck, most certainly that person would not have died. It is because of that, my lords, I say that my act is not the causa causans, which is the requirement under section 304A or the current 103 BNS. Now, my lords, based on this, I say that the act of negligence may have been of the truck, because that was inherently negligent. They don't say that he took to the ground because of me, and then a normally driven truck unfortunately crushed the deceased person and went away. The truck was also individually being driven rashly and negligently. Now, if I may just see the 161 statements, because my post conduct also would be slightly relevant in this matter, the type of argument which I am raising. The 161 statement, my lords, will find on. This is, my lords, page 73.
Your act is causa sine qua non.
My act may be causa sine qua non. Of course, I can't make any admissions, my lords. But reading from the case,
at most it may be causa sine qua non.
At most it will be causa sine qua non. It may have been an essential ingredient which caused for the incident to construct in such a manner.
Not the immediate cause.
It was not the immediate cause.
Immediate cause was the truck crushing the person.
Yes, my lords. Absolutely.
Now let's see what the Supreme Court says.
My lords, may kindly have the judgment again, 1972 3 SCC 525. Second item on the reference column, my lords. For my lords' convenience, I will read once again. This is in the first page only, what has been held precisely. In a prosecution for an offence under section 304A of IPC, the court has to examine whether the alleged act of the accused is the direct result of a rash and negligent act, and that act was the proximate and efficient cause of the death without intervention of others' negligence. The mere fact that an accused contravenes certain rules or regulations in doing an act does not establish an offence under 304A IPC. The act causing deaths must be the causa causans. It is not enough that it may have been the causa sine qua non. The
in
court
that
has
case, what
to...
had happened? In that case, this is a case of spurious drugs.
Yes, Mala. 12 persons had died because of a certain drug which was being manufactured by this person without following certain rules. That was the facts. But the general proposition of law, bereft of the facts, was that if there is the element of a third person's intervention, then of course my act, because what needs to be seen, because this is not an act, it's an omission. There are two types of offenses. One would be an act, one would be an omission. Here, my act is one of an omission where I negligently, had I with due care and caution done it, I would not have opened the door possibly towards the road. But since it's the omission is that of prudence, that has to be the direct cause of the death. And my lords may see the postmortem, that most certainly is not. Now I opened the door, he fell to the ground, and as per the FIR and the entire prosecution story, the truck was also coming rashly, negligently, and speedily driven. Under which, most unfortunately, my lords, the deceased person lost his life because of those crush injuries. Now, had there been no truck, that is the intervention of this third element, most certainly he would have taken to the ground, might have even sustained some minor injuries, gotten up, and then he would have proceeded ahead. And that is the specific definition of causa sine qua non versus causa causans. Causans being itself, the word sans being used in that means the absence of any third element. That is why there is no secondary cause of action. That has to be the sole cause of action, is the meaning of causa causans. And causa sine qua non being an essential ingredient. And the standard has been laid down. It can't be causa sine qua non, it shall be causa causans.
In this case, what had happened? In the case of Ambalal, you are the chemist.
Yes, my lord. I was the manufacturer of said drug.
No,
and there were certain
chemist.
Yes, I was the chemist. And in violation of a good set of rules, I was preparing a particular drug on consumption of which 12 persons had died. And a charge under section 304A was laid against me. So they say that since the rules were in violation, you being a chemist ought to have known that even a degree here and there can be fatal. But since you were in violation of that, that is why your act is negligent. The law was that I may have been negligent of a rule, but directly that being the cause. In fact, on facts, I would submit, my lords, that my case would be slightly better than this, because a chemist missing out on a certain chemical by a degree or two, that is far more prudently negligent than me, because in the facts of the instant case, I did something which every commoner does. It's a very common thing which happens. Very rarely will lightning strike at the same place twice. And not only will a man fall to the ground after me opening the door, but also will a truck being rashly and negligently driven pass by from there. Based on this, my lords, what we submit is, for now, if my lords would like to test this argument, the trial proceedings may be kept in abeyance. The state may be called upon to file whatever return they have to file. And my lords, this petition, because we say that it is a case which 304A would not be made out, subject to after my lords hears the state.
Yes, Mr. Delhi, I consider the argument. And suppose I'm not satisfied, then would you like to have an order on merits or something else?
No, in that case, my lords, I would not want to prejudice the trial court, because I'll withdraw the petition, but I'll sincerely request, my lords, that my lords may kindly consider this.
I'll consider the alternative prayer also, main prayer alternative.
Deeply obliged. If my lords are considering, then I would press that there's a stay application, because then before this matter gets in fructus, we'll decide it legally, and then we'll trial maybe stay. I'm deeply obliged, my lords.